welcome to the webinar. What your IP attorney wishes you had known before starting your company. Panel co-hosted by QB3 and the Berkeley Center for Law and Technology's Life Sciences Project. So I'm going to introduce myself, and my co-host Allison will introduce herself, and the panelists will introduce themselves. I'm Casper Mossman. I manage communications and pre-commercial programs at QB3, which is the University of California's life science accelerator. Originally based at UCSF for quite a long time, and we recently moved to Berkeley, where we're housed in the Baker Labs Incubator, which is a fantastic space in the former Berkeley Art Museum on Bancroft. And one thing we're actually really excited about is all the resources for entrepreneurs and the ecosystem that's springing up at the Berkeley campus. Right across the street from us is the School of Law, where Allison, my co-host, directs the Life Sciences Project. Hi, Allison.
Hi, thanks, Casper. So I'm Allison Schmidt. As Casper said, I'm the director of the Life Sciences Project at the Berkeley Center for Law and Technology. This project is new. It's only been going for about a year. Our goal is to be interfacing more with the campus in a variety of different ways, really bridging the gap between the law and the innovation practices going on campus. And so this is a terrific way in which we're working on engaging with QB3 and with all of you. So I'm also a lecturer and a fellow at Berkeley Law. I graduated from Berkeley Law many moons ago, and prior to coming back to academia, I spent several years in private practice where I was a patent litigator and did pre-litigation and strategy and policy work related to the life sciences. So our goal for the panel today is to really explore the question of what early stage entrepreneurs and founders need to know about their intellectual property before you meet with potential partners and funders. So we're going to talk about why you need an IP plan, how to understand the IP landscape around your invention, what the diligence process looks like when you're seeking collaborators or funding, and how to approach lawyer to represent you. Put together a great panel today. We've got a legal expert, we've got serial entrepreneurs, and two very experienced investors to answer these questions and your questions.
Yeah, so 2 points before we get started. We are recording this, and we will be emailing a link to the recording to everybody who signed up, as well as eventually posting on the QB3 YouTube channel. You should be able also to find it at the Berkeley Center for Law and Technology's website, which I believe is bcle.berkeley.edu. But anyway, you can check that out, and we'll be emailing you the link. So let's introduce ourselves. Ali.
Thank you, Casper. Hi, everyone. My name is Ali Alemozafar. I'm a partner at Wilson Sonsini. My background, I'm a scientist by training. I got my PhD at Stanford a long time ago, did a postdoc at Harvard in chemistry, looking at nanoparticles. And I went into patents in 2005. I joined Wilson in 2008. My practice is almost entirely focused in the life science space. We do everything from tools to therapeutics to diagnostics, digital health. We have about 180 attorneys and patent agents across our various offices. We have the world's biggest patent group when it comes to the life sciences. We've helped companies in the DNA sequencing space, therapeutic space, and so on. And looking forward to talking to you all about various important topics in patents.
Great. Maria?
Hi, good afternoon. My name is Maria Fardis. I'm a venture partner at Fraser Life Sciences. Fraser is a fund that invests in both private, public, as well as in company creation. I'm responsible for company creation along with the rest of the team. I'm a chemist by training, got my PhD at UC Berkeley, as a matter of fact, and have been working in Bay Area biotechs for a long time. My last maybe 2 jobs are worth maybe noting. Previously CEO at Iovance Biotherapeutics, where we were developing cell therapy for solid tumors. And prior to that, COO at Acerta Pharma, where we were developing one of the, I think, the best-in-class BTK inhibitor in inhibition, and is now in the market, acalabrutinib, and I think is capturing the CLL market quite broadly. It's a pleasure to be here this afternoon.
Thanks, Maria. Neena?
Hi, I'm Neena Kadaba. I'm an EIR at Appletree, which is another venture fund focused very much in the company creation space. I've been at Appletree for just about a year now, and prior to that, I was an investor at Quark, as well as a corporate venture group at a Japanese company called Itochu, and I was also at QB3 for a number of years. I'm also a scientist by background. I did my PhD at Caltech, and very happy to be here.
Thanks, Neena. Uri?
I have to see if I can find the mute and unmute. Hi, I'm Lopatin. I'm an infectious disease doc by training. I was at a bunch of big pharma, Schering, Roche, Gilead. Went on to start a couple of biotechs, Assembly Biosciences and Fardis Biosciences, with a stop in between in investing, where I was the visiting bio partner for Y Combinator. And it's a pleasure to be here and try and answer some of your questions.
Cool, thanks. Greg, last but not least.
Yeah, last entrepreneur at least. Greg Went, I'm a PhD out of Berkeley, 1989 in chemical engineering. I've spent my 30 years in and around biotech. Was a co-founder of Curagen, one of the early genomics companies. Advised a bunch of companies during a brief retirement, and then was the CEO and founder of Adamas Pharmaceuticals, where we developed a couple of products in the Alzheimer's and a product in the Parkinson's space and got them approved. I am a CEO of Reflection now today, which is a Baker company, and very happy to be here today.
Thanks, Greg. By the way, Greg's calling us from the Denver airport, so please excuse any audio blips. Cool. Allison, let's kick this panel off.
Sounds great. I'm going to make one quick housekeeping note, and I think Casper's also noted this in the chat. So we're very interested in audience questions. Please feel free to put those in the Q&A. We'll look forward to getting to those towards the end of the session. We're hoping around 1:45. But please keep the questions coming. So let's kick off. Ali, I'm going to throw the first question at you. So, if we're talking about IP, I think, the first question that many in the audience may be asking is, why should you care about having an IP strategy? What do patents do and not do for you?
Yeah, fantastic question there. You guys are all working on concepts and ideas that are very very essential to your businesses. They are worth more than gold and platinum. And we want to make sure that your ideas are captured, that the value in these ideas is captured. And for a company that is very as a startup that is very early stage, the value of your company is almost entirely captured in how you protect IP. Whether it's by keeping it as a secret, and you should all be doing that, but we're thinking of ways of patenting these concepts, because patents would give you the option to stop the someone out there that may be copying you or may try to copy you. And with trade secrets, you can't really do that. With patents, though, you have that stopping power, the potential to stop the bad guys out there that may try to copy you. We're not talking about getting you guys into lawsuits, but it's really about preserving options as a way to preserve value for your companies as you guys move towards commercialization. And through the course of financing, and whether there's a future exit, whether it's an M&A or IPO, or even if you guys just want to keep generating revenue, patents will be critical for these various business inflection points. And it's really coming down to helping you preserve value and options going forward.
Let me ask a similar question to our entrepreneurs. So when did you really, during your careers, when have you really appreciated the importance of having an IP strategy? I think Yuri, we'll start with you.
So to use the same quote as last time, I think it's always important to begin with the end in mind. You at some point down the road, you're going to be marketing either your process or your product as part of your fundraise and ultimately your hopefully go to market. So since a lot of people in the audience are scientific entrepreneurs, it's highly relevant. You have to think about, how do you get the cadence of what you want to say out there mapped out in such a way that you're not getting ahead of your skis and talking about things in a public forum before you have the time to do that. If you have academics that are on your team that want to go out and say, we have this fantastic X, that's part of why people might invest in you, because, and that's something that we lived through. We had academics from our companies that wanted to talk about what they had was great. And we had a lot of conversations about, when can you publish what? If we have to file patents and we have to go to investors and we want to show them things that are hopefully being seen for the first time by those investors and the IP lawyers, long before the public markets, because otherwise you're in a free for all, and sometimes it's hard to play catch up. So that's always been a fun seed conversation.
Greg, I know you've got some thoughts on this question as well.
Well, just riffing off of what Yuri said and Ali, I love the begin with the end in mind. And it's like that swimming analogy, right? Where they tell you to imagine the entire race before you get into the pool and get to the end. And if you're a first time in your 20s doing this, you may say, well, what's that point I need to imagine myself in? And, you know, if you're successful, there's going to come a point, Ali's comments notwithstanding, where, you know, the patent doesn't give you the right to do anything other than to sue somebody who is infringing your patents. That's what it gives you. And I think I would encourage people to ask questions of their attorneys and of themselves along the way. Do I understand what that event is going to look like? So, you know, some of those events that you're going to encounter in your life. And so the best way I know to think about it in this instance is, you know, you're think of yourself as an inventor being deposed at some point down the road. You're going to be asked about every element of this patent because they're first going to try to invalidate it. They're second going to try to show that you've committed fraud somewhere along the way. And these are terrible words, I know, but the reason why you want to have a patent strategy is you want to be really relaxed when Ali's sitting across the table training you for that event that occurs well in the future. And you want to, you know, along the way, really make sure that you got your inventorship, you got your idea described well, that it covers the product that you want to sell. You have your inventorship correct. You know what all the prior art are, and you don't make any foot-fault dumb mistakes along the way by not listening to your attorneys. And you really have to look at your attorneys as an equal partner in this. You need to understand what that event's going to be like, that end game point, because when it comes, you want to be relaxed and just focused on what happened.
Thank you for that from both of you. How do you think about the ongoing cost of having an IP strategy? I think Yuri will start with you and then open it up to the panel.
So I think this is something you have to budget for. And I think this is a mistake as well that I've seen people make. They don't think about the cadence of the cost. It doesn't cost that much to do a thorough job up front, and it costs an enormous amount to have not done it. And so I think that is probably one of the most important conversations fledgling entrepreneurs can and should have with their lawyers in terms of what is the most important set of protections to get, realizing that they're going to have to do more and realizing that the costs are going to grow non-linearly. And when they're raising their money and planning out their timelines, they have to think about very realistically, how are we going to make sure that our raises are going to be able to feed the ravaging monster, I mean the legal costs of a filing that may be done around the world, as opposed to just in the US or just in the single country they might be from.
Anyone else want to weigh in on that question?
You know, Yuri hit the nail on the head. Just thinking ahead about sort of costs and budgets, and there are ways for startups that are, you know, very early stage startups don't have much funding, and so it makes sense to find ways of getting the patent filings there while also helping to keep costs down. And there are ways that lawyers can help you guys do that. You can file a provisional patent application, which will buy you 1 year to keep adding updates upon updates upon updates. It'll get you a filing date that's good in the US and for the whole world. And then 1 year from filing that first application, is you'll file it as a PCT case internationally. They'll give you another 18 months to then file in China, Europe, US, Japan, and so on. In the life sciences these days, it's not just a US play, it's a global play. And lawyers can help you guys figure out a strategy to get your filing there, while also helping you keep your legal costs down, so that you guys are not breaking the bank on your IP strategy.
And I would just add to that, put no pressure on yourself to publish anything, despite what anyone has told you, because that's where you end up tripping. And I've heard so many entrepreneurs say that the venture people really love to see marquee publications. Ali was right. All of your value is in your IP. None of your value is in your publication. They can read your internal reports just fine and understand what you're doing.
We're going to dig in a little bit more on the published versus patent question in a little bit. Let's get our funders, our investors involved in the conversation here. So from your perspective, what's the importance of having an IP strategy? What do you expect to see from these early stage companies before you're going to consider funding them? I think, Maria, why don't we start with you?
Sounds good. So it really depends. Of course, the data ownership is the key for any biotech company. I think that my prior sort of panelists have emphasized that over and over. That is what we have. Our IP is all we have in a company. If the company is in a very competitive space, I would love to see FTO, freedom to operate, from external counsel, not internal, external. So someone else has put their eyes on the company's patents and they're telling us that they have freedom to operate. That would be really ideal. If the company is not in a competitive space, they're really first in class, it's a completely brand new target, then I suppose I can live with a file that maybe a granted patent would be really ideal to see. So what we would expect to see in terms of investment opportunities would depend on how competitive the space, the scientific space is. I usually sort of tailor it that way. I don't know if Neena has any other thoughts.
Yeah, I think for us, it really depends on the stage of the project, if you will. If the effort is very early, I think we're comfortable if there isn't yet a filing, but we understand the path to get there and the work that has to be done. I think it really will depend on, what the specific project is and what the right time to file is as well, because that filing also starts the clock on how long you have something.
And so that actually sort of segues into the next topic, which is how do you get a view of the IP landscape surrounding your invention or discovery? And I have to mention that we're partnered with UC Hastings to help scout them to find candidates for their IP landscape program. Their law students at Hastings are teamed with blue chip lawyers from around the Bay to explore the IP landscape of your company's technology. And as it happens, the deadline for that application is Monday, this coming Monday. So you could go to QB3.org to find that program if you need to apply. But Ali, tell us about these, what's involved in an IP landscape exploration or FTO?
Yeah, fantastic question there. It's not just a matter of opening up Google Patents and typing in some keywords. We very carefully think about the tech that we want to search around, thinking of ways that patent lawyers could have termed things, looking for alternatives of terming things. So we're really trying to cast a wide net while being mindful of your budgets and trying to find the patent out there that could be a problem. It could be a showstopper, and finding that and finding ways why it is either not valid or finding ways to work around it, to work around it, and we do this constantly. And so it requires a carefully structured search strategy and then executing that to pull down a few hundred, a few thousand, many thousands of patents, which we have done of various different flavors, and looking at those very carefully. And lawyers have to do this because patents are very, very unique beasts, and how these are read is very special. So lawyers have to look at these to say, here's why you guys don't fall within these patents. And for those where you may fall into them, here's why these are not valid. And now, without scaring you guys, I mean, these can be expensive, but for a company, and depending on where you are commercially, the size of the search can vary. So for a company that is just new, it may not make sense to do a very broad search that could cost thousands upon thousands of dollars. We can work with companies to structure the right level of search to give future VCs comfort to invest going forward.
And what's the distinction between FTO and an IP landscape search?
Yeah. the FTO, it's basically so they are basically almost the same thing. It's just that a landscape is more about, let's see what's out there as we develop our platform or our tech. Whereas an FTO is, we know more or less what our technology will look like commercially. Let's do a more focused search around that specifically. So for example, if you're a CRISPR-Cas company and you want to get clearance on your particular class 2 type 2 enzyme, we could do a search around that, around the specific sequence of your Cas versus more generally looking at what does the Broad have, what does UC have, what does Beam Therapeutics have, Harvard, and so on. It's really based on where the company is commercially, whether it's a landscape search or an FTO.
Okay, thanks. Allison, I think you have the next question.
I think so. Let me put in a really quick plug. So, folks who are interested should definitely be applying for the Hastings program. Berkeley, actually working with Ali and some of his colleagues, is going to be putting together a similar program starting in the fall, where we're going to have law students and PhD students involved and engage with early stage companies looking at their IP landscapes. I think it's going to be terrific. So if you're interested, please feel free to reach out to me. We will certainly circulate the application through QB3 and others. When
excited to be
closer.
Helping you with that.
Yeah, I think it's going to be, it's something I wish I had been able to do as a law student. So, that's generally how I judge whether or not we should be going forward with something. So my next question for you, and it's mostly directed at you, Ali, it is related to the freedom to operate question. I used to get this question all the time from clients. So if I've got a freedom to operate, does that mean that I have the freedom to do what my patent covers?
Oh, fantastic question there as well. The answer, unfortunately, is no. These are different exercises. We want to, on one hand, help you guys to protect your IP, your core ideas. And over the coming months or years after filing, there are various ways to speed things up. You can have a patent that will protect what your play is, what your concepts are, and so on. But that doesn't mean that someone else out there doesn't have a patent that could cover various aspects of your technology, a broader patent that could maybe block the whole space. Maybe to give you an example, you guys may have your own specific CRISPR Cas enzymes with your own novel sequences, but there are broader patents out there that block the use of a class 2 type 2 enzyme for gene editing. The Broad has those, the UC has those. So it's having your own patent doesn't mean that you have the freedom to practice what the patent covers. That's a little weird, but that's why we also want to be thinking about, apart from getting you guys your own patents, we also want to be thinking about helping you navigate around the landmines out there on the freedom to operate side.
So, as you're thinking about your IP landscape and your freedom to operate, you're going to be thinking about what we in the patent side call prior art, the body of literature. It includes patents, but it can also include publications, a variety of other types of things that may have existed prior to your invention. And so another question that comes up very commonly is, what are your responsibilities as an inventor to understand the prior art? I think that this can be a little bit of a surprise. I'll say a couple of things and then I invite Ali and others to jump in. And so this may sound scary. I promise it's not. So applicants for patents owe the Patent and Trademark Office in the United States, we call it a duty of candor and good faith. The goal here behind this duty is to ensure that the PTO is patent applications based on all of the information that's known to be material to the question of whether or not you should actually be able to get a patent on that invention. And so this duty of candor and good faith applies to individuals who are associated with the application. It applies throughout the entire time that the application is being prosecuted. Those individuals include not only the attorneys or patent agents who may be actually filing the application and doing the back and forth with the Patent and Trademark Office. It also includes every named inventor. And inventors actually have to acknowledge this duty in their inventor declaration that's submitted along with the application, and as well as anyone else who's substantively involved in the prosecution or preparation of the patent. So how do you comply? How do you satisfy this duty? The idea is that you need to disclose anything relevant, all relevant information in publications and documents to your prosecuting attorney or patent agent. And so, they'll work with you to review this information. What kinds of things can these be? Certainly, papers, patents, that type of thing. Anything that describes a device or method that's similar to that's claimed in your application, or that discloses a portion of what you're claiming in the application, can be promotional literature. I've seen user manuals. I think in our space, it's fairly common to see conference proceedings. I've worked on many cases where an abstract from a conference ends up being an important piece of what we're considering in terms of patentability. What can happen if you don't do this? I guess this is the scary part. There can be serious consequences if you haven't disclosed everything that you know of. It can lead to a court finding your patent to be unenforceable, so you can't assert it against other people, or it can lead to sanctions. So it sounds scary, but you do have a personal accountability as an inventor to understand the documents that you're aware of and to be able to share those.
Does anybody have any panelists have anything to add to that?
Well, I'm smiling. Don't be scared, right? You are a partner as you start this freedom to operate exploration and identifying all the prior art and whittling it down to the course of art. You're a partner with your attorney. And to the point Ali and Allison have made, you want an attorney to take their look at those things, but don't be afraid of looking at every single one of these references and informing yourself. Many of you are from Berkeley. I was taught when I was getting my PhD to know every problem that's been solved out there. That was a phrase from, I think, Albert Einstein when people came to the Institute of Advanced Physics. So as long as you're a good human being and you don't represent things fraudulently, the worst thing that can happen is you make a mistake and your patent's determined to be invalid. It can happen at the wrong period of time. It can happen all the way up in your first diligence when someone like Ali comes in, looks at you from the other side of the table and says, you've missed a whole bunch of stuff, but it's not too late to fix it. We still want to invest. Or you've missed too much stuff. You really don't know what you're doing. And be on the other side of that where you're actively engaged, and it can be a lot of fun to protect your own idea.
Great. Uri, you've got your hand raised.
Yeah, I want to double down on that, because not only is it not scary, there's actually no additional work here. Theoretically, if you're creating a company around an area in which you're an expert, you should know more about this than anybody else in the world. And it means you should know what's been published. You should know what the guy next to you and other folks are doing. If you don't, then it's going to be hard to convince people to invest in you. And if you do, then being able to provide an up-to-date list of here's the things that are going on that make what I'm doing special is part of the course anyway. So it's not, I don't think people should view this as an additional burden, but rather this is part of what it takes to demonstrate that you are the best at what you do.
Cool. Neena and Maria, anything?
Yeah, maybe I'll put a pitch in as a chemist. I think it's really critically important that you keep good contemporaneous records, and that your notebooks or your source of invention is countersigned and in real time. So pay attention to what your counsel may be telling you. I think a lot of people in academia necessarily don't think about that, but if you think you're going to out-license your invention and you're going to start a company around it, this better be extremely solid. People do think alike in sort of a scientific landscape, and it's very likely that someone else is having the same idea as you're having somewhere else. So make sure that you capture your innovation in real time, and you make sure that you file and talk to your patent attorneys in real time.
Great. Anything to add, Neena?
No, I think they covered it very well.
Cool. Hey, Allison, okay if I proceed to publishing?
Please go for it. I'll just put another quick plug. We're getting some great questions in the chat. Please, here in the Q&A. Please keep them coming.
Hey, so yeah, earlier the topic was brought up of emphatically described by Greg, I think, that, don't pay attention to publishing. You want to patent. If you're going to commercialize the patent situation, you need to get things patented before you publish. This is a major challenge for postdocs and grad students whose basically their entire lives depend on them publishing something, getting out of the lab. So how do you approach this as a grad student and a postdoc embedded in an academic situation? You've got something that you think you might want to commercialize and everybody's telling you, publish this, and you're like, my God, this is the only way I'm getting out of my PhD. So I publish. What advice might you have for a student or a postdoc in that situation? I guess we'll start with Ali again.
Sure, happy to. And certainly appreciate the challenges there, because I myself was a scientist and fully appreciate that we as scientists want to publish and so on. But the name of the game is to file a patent first and then publish after that. And the way to do it is schools like Stanford, UC Berkeley, and so on have fantastic OTLs, licensing teams there that can help to assess whether a given invention makes sense to file on. Is this something that they care about? And usually, if it's something that the PhD student / postdoc and PI are very excited about, most likely they will go forward with it. And so they can help with that filing, help with those costs that once that IP is then licensed, you guys would then pay for through and so on. But that will help you guys get the filing date locked down before submission of your manuscripts to Science or Nature.
So are there challenges that arise if you file that patent too early? What might they be?
Maybe someone else wants to handle that one, but I'm also happy to do that too. But
Uri?
Well, and it's something I think people don't appreciate, is most of the value of your patent is going to come in the last couple of years of whatever it is, particularly in therapeutics, because you have to make the thing and you have to sell the thing. And it turns out that building the supply chain and the marketing force and getting people to know about what you're doing take time. So you are most likely going to have the best ability to actually capitalize on whatever it is that you've done in the last 2 to 3 years of the patent lifespan. So the longer you can give yourself to make sure that everything is a smooth run to there, the better off you might be. And that, of course, you're going to have to weigh that against somebody scooping you, but that's the fun of it.
Cool.
Yeah, and I think patent strategy, and it's really hard to do, Casper, under the situation you just described, right? Because you don't have a company, you don't have a product profile written out yet. It's hard to imagine all the directions thing could go in with your, a graduate student. And I think the one thing to keep in mind, I think Yuri could weigh in on this as well, is if you've got a good idea that this is what I want to publish, but my product sits over here and is a invention away, right? Get this done when you're an academic, keep this part to yourself, get your company formed around licensing this and developing this, and then keep your mouth shut on this. Because to Yuri's point, you really do need, if it's 8 years of development, you don't want to have filed that patent. And this is to Neena's point, going into Series A, you want to explain your patent strategy and honestly say why you haven't filed the patent yet and what data you're going to generate in order to get to a patent filing later. And we did this in my last company, where going into a phase 2 poster presentation, filed a patent 2 days before the poster presentation, to Maria's and Allison's point. That patent added 7 years of patent life in the Orange Book to a product. And had we missed by 48 hours, we would have been hosed.
Wow. And an interesting comment about thinking about whether your invention is related to your academic research or whether it's just something you can keep in your head. We've certainly seen a couple companies come into our incubators that were founded by grad students who were developing something that was not their PhD, but they've been dying to get started on it, commercializing it. And as you know, that's a question we get from early stage, even faculty, is how do I separate my academic and my commercial work? Probably for that reason. Okay, Allison, you want to talk about due diligence?
Sure. This is another area where we're hoping to demystify the process a little bit by working through it with our panel. And so we're going to talk about what the diligence process leading to a funding round actually looks like. And I think we can start with the funders. I think Maria and Neena, you've addressed a little bit of this already, but we could dig in a little bit deeper. You know, what do the inventors need to do to demonstrate the value of their asset with respect to their IP? What are potential pitfalls that you have seen, I suppose, hypothetically, rather than actual examples? You know, what are you looking for with respect to IP?
Maybe Neena should start this time.
Oh, sure. So, I mean, I think it depends on the stage again of the company and of the project. And in previous funds that I've worked with, you know, it's more straightforward. There's some clear assets that you're looking at. There's a lot of IP that's been filed, and then you work with firms, you know, like Wilson to understand, can we get an IP diligence to see where are the red flags and are any of them addressable? I think that's a great way that many funds start with, that to say, if there's a red flag, can we figure out what to do with it? Is there a path forward or not? And we've had situations where the answer was yes, here are the red flags, and then here's a plan. And frequently the team that we've worked with can help in that process, assuming we make the investment to help the company address those issues. And there are other times when you identify that there are major problems that you can't deal with, or you can't deal with in a way that would give the investor enough comfort. And so that's, you know, another category. But really, from our perspective, it's always working with, you know, some counsel to sift through the issues.
And I echo that. I think that we did talk about what are the big pitfalls. Big pitfalls are publishing without duplicating what my panelists also already talked about. The concept of publishing versus patent filing is something the companies even think about, not just graduate students, but in a company setting, you do need to publish your data because that's what the KOLs are looking at. Those are peer reviewed, so they're not really interchangeable. A patent filing is not the same as publication. A publication is peer reviewed. Patent filing may or may not be in the same degree that a publication is. So companies think through this very carefully about what how to publish it. And Greg covered this really nicely, that you don't have to put all of your cards on the table. You know, put the concepts that you can talk about publicly out on the table, but some you might have to hold until your patents are filed and ideally maybe even published. So big pitfalls are publishing without filing. We talked about this extensively, and not knowing who's in the competitive landscape with you. And Ori talked about this as well, that we really should know who else is in this space. Honestly, that's part of the job of a scientist in an organization. So those are the two big no-nos from my perspective.
That's really helpful from both of you. Neena, I have a question for you specific to the academic landscape. I think that a lot of our audience are academic researchers who may be looking to transition an idea, you know, potentially commercialize it. What specific challenges can you highlight for us in transitioning an academic project to industry, and how can academic inventors be preparing themselves for these challenges?
Sure. Well, I mean, I think you have to view your tech transfer group as an asset in making that filing. You know, you should have a conversation with them as soon as you think you have something that's worth filing on, and keep that conversation going. I mean, I think if there's something that you don't need to file on, or if it's a project where you anticipate the filings would come later, that's a different story. But if there's work that's been done at the university where that should be filed on there, that's the place to start. And I don't think there's any way around that. So I think being aware of what it is you're creating, what it is you hope to file on, certainly have conversations if you can with other folks, but I wouldn't invest in a, private counsel of any kind, because what you're doing is really focused on, academic IP at that point.
Please go ahead, Yuri.
I will just add, even when it is academic IP, to Neena's excellent point, the tech transfer office should be your friend, particularly if you plan to spin things out. So it should be collaborative in terms of how and where you file. And if you have that process set up early on, it's much easier when you're trying to spin things out later. And it's also much more likely that you're not going to have missed anything, like, oops, we forgot to file in this country, where it turns out we probably should have filed. That you avoid mistakes if you have conversations long in advance of when you actually want to commercialize or enable yourself to commercialize something.
That's right. It goes back to what Yuri was saying before, that you need to be the expert in what you're doing. And part of that starts then when you have to think about where should you file, when should you file, what should you file on? You know, you have to be part of that conversation.
I'm actually going to incorporate a question from the chat that is really on point in the sense we're getting close to 1:45 that's related to this from Laura Hertel. So what's the funder perspective on products that have a patent assigned to a university and would need licensing versus a patent that's assigned to the founder? Do you look at these patents differently as assets? Is there an issue in terms of valuation? Are there considerations that you think about?
I mean, from our perspective, I don't think so. You know, it's if it's at the university and it's something that we want to have, it's a license that's worth pursuing. You know, I don't think that's a barrier that's insurmountable by any stretch. I think for most of the university projects, it's unlikely that it's going to be just a founder that has that IP if they did work at the university and university involved. I think the university involvement also validates your project, right? I mean, so I think there are costs associated with it, but there's also a benefit to being part of the university and having it that way.
Wonderful. Maria, I have a question. Oh, Ali, please go ahead.
Oh yeah, but yeah, just to echo everything there. I've worked with many companies that have licensed IP from Stanford, UC, MIT, Harvard, School X. And as long as the core IP is exclusively licensed, that's just as good as the company owning it. And then it's also important that not just that IP, but any future IP, to Yuri's point, that is generated, that these companies think about, where was it generated? Did it involve the PI at School X, or was it all done at the company? And I've seen companies worry about, well, if I have to license this more, that's bad, but it's actually part of the game, and nothing to worry about. Schools like UC, Stanford know that companies will have additional IP, and some of that could be generated within a given research group, and those could be included in your license. So it's just a matter of having a strategy there to capture future IP.
Greg, please go ahead.
And Casper asked me to be a contrarian just once during the course of this. So I would just say, though, and not to be a contrarian too much, but the better you understand the product you want to develop, the better you can write claims and the better you can write a specification. And this goes back to Yuri's theme of begin with the end in mind. It took me a long time to get to the point where I started with writing a product profile, writing my claims, then writing my specification and my examples, actually examples, then specification. And that, generally speaking, doesn't happen in the rush for an academic licensing office to write a patent application to allow you to publish your paper or go out. And so, again, nothing scary about it. We generally spend a lot more money on the company side getting that stuff right. And it's the difference between validity at the end of the day and something which is really uncomfortable at the end of the day. So I do encourage people, Casper has seen me do this, to, if you've got a concept, keep it to yourself. If it's good enough to form a company around and raise money from these guys, you should be able to write down a product profile at that point in time. And that's when you call Ali and say, I've got a new company. Will you front me some money so that I can get my patents filed? And Ali will typically say yes.
So that means you need to be, you need to have that need in mind that you're meeting. You need the need and then the product, and then you write the patent. And I mean, the academic mindset is, I've got this discovery, let's patent it, and we'll figure out how to apply it later.
That shows up in the quality of the patents at the end of the day. And some of them are great because the need and the product is clearly in mind at that point in time. But again, back to Yuri's point, I have found that to be the exception to the rule.
Great. Greg, do you have to take off? I know you said you were going to have to go.
Thank you for joining us.
Thanks so much.
I ended on a contrary point, so I hope I get some points from you, Casper, for that. Thanks, everybody.
Totally. Have a safe trip.
Thanks.
Casper, I think in the interest of time, we should jump forward to the last question that you were going to ask, and then I think we can jump to audience questions.
Right. Was that how do we? Yeah, we have.
Yeah. How do you
one lawyer? Which firm should we choose, Ali?
Yes.
The question is like, how do you How do you pick a lawyer? How do you pick a firm that's going to work for you?
Yeah, look, frankly, guys, you should pick a law firm and a lawyer that you trust, so you should maybe pick a few and have a chat with them, make sure that they understand your science and the tech, that they understand your business. That's key, that they understand your business. Having a patent that doesn't cover your business is worthless, or doesn't cover someone else's business. Patents have to cover somebody, and they should either cover you or cover someone else if they're being used offensively. But your lawyer should understand your business, they should understand your technology. And so you can talk to us, you can talk to other firms out there. But that's first and foremost. And second is your law firm should understand what it means to help startups. Not every law firm does, and we do. We have programs there for startups. We can defer fees and so on to give you the mileage to get your patent filings in place. Also, make sure that your law firm understands what it means to help a startup.
Great, thank you. Cool, Allison, we've got some audience questions.
We do. I think I'm going to start with a question that's not about patents. So we've been talking about patents primarily as the major IP asset. I certainly in my practice, and Ali can weigh in here as well, certainly seeing trade secrets pop up more and more, depending on the type of technology, depending on how you were thinking about protection. So let's talk about trade secrets for a minute. Should companies elect to keep certain technologies trade secret as opposed to pursuing a patent? How do you determine which ones? And is there an investor view on using trade secret protection versus patenting or otherwise?
And who's that question from?
Sue Wong. Hi,
Thanks.
Sue. Sue's my former colleague. Hi. It's a great question.
Anybody want to take that?
I can start. It's an interesting question, but not one that we've thought of too much, mostly because we work in the therapeutic space, and most of that value that you're generating comes from having, filed IP that you can then license to other folks in the, at the end of the day. So it's not something we've thought of too much, not to say that there aren't technologies where it would be most appropriate, but I haven't found it so relevant thus far.
And in my past life, we have used trade secrets for a different purpose than IP, although they can be overlapping. But for example, your logo, your name, your certain sort of associations that you have with your product, and you don't want someone else to take it, that's trade secret, while your technical know-how has been usually covered by IP. I think Ali should speak to that more, but that's how I've separated those in my past life.
Yeah, and just to chime in here, when we think about patents, they actually start initially as these concepts are being hopefully kept as a trade secret. So when you file a patent application, before it becomes public, it's a trade secret. And so all inventions at some point, hopefully, are being kept as a trade secret because they have value to your business and so on. But we as patent lawyers think about what to patent, especially in the life science space, where if you're putting a product out there or you're selling something, you want to have a patent to cover that first and foremost. And we also think about, can we keep the specifics of this invention as a trade secret? The specific details of this concentration of X to this molar ratio of Y, can we keep that as a trade secret while patenting the IP at a higher level? So that's what we think about, is to use the best of both worlds. And to Neena's point, there are some inventions where they are best kept as a trade secret in the life science space. That tends to be rare. But things like machine learning platforms with a specific algorithm with weighting factors for X, Y, and Z features, those we may keep as a trade secret, because even if you have a patent, the patent will be so focused and so narrow to have almost no value as a patent.
Thanks. Sorry, can I just bring up a question I see which looks interesting? We haven't talked about confidentiality. A question from Tom Rueg, about to file a provisional on a prophetic invention, a process. After having a filing date, I plan to collaborate with partners to develop the process. How can I make sure my invention is secured besides an NDA? So I'm not a lawyer, so that question makes sense to me.
Yeah, there's this notion of public use and public disclosure, where if you talk about your invention publicly, or even if you sell it, that could hurt you from a prior art standpoint. what we recommend is if you can, when you're talking to future employees, future partners, or whoever that is not within your company, have an NDA in place. If you can't get that, at the very least, have the concepts that you'll be talking about in a patent filing before you talk to such person.
Anybody else have a comment on just general confidentiality and speaking to at the early stages?
So I will double click on that, because I do agree that the NDAs are extremely important, but again, coming back to the idea that hopefully the inventors and the entrepreneurs are the experts in what they're doing. We also hope that it's not easy. If it was easy, everybody would be doing it. So part of being an expert is the ability to talk about things at a high level without having to give away everything. And if it's not possible to do that, then probably other people are already doing it, and you're too late. If it is something that you can talk about at a high level and not give everything away, then you're going to be able to represent what you're doing well. And hopefully it is challenging, and that's why it makes a great business.
Great, very insightful. Allison, you want to bring up another question?
Yeah, I'm flipping through our list. We have a question here from Eugene Major, and it touches on a topic that I think we briefly addressed with respect to seeking IP protection outside the United States. And so I think Eugene's question is really, can you discuss major issues that you may see come up relating to seeking that type of protection outside of the US? For example, you're working on a university technology and deadlines for filing foreign patents have passed. How do you approach in that scenario? I think it can also be a broader discussion of, how do you approach thinking about seeking protection in the US versus other jurisdictions? Do you need protection everywhere? Yes, no. I think, from the lawyer perspective, I know the answer is it depends. And I can see Ali's smiling. So let's let Ali start.
Yeah, it's a function of your budget, ultimately, and we can't file patents in every single country on sort of here, so it's too expensive. But what we think about is to have patents in your core markets, and this tends to be in the life science space, the US for sure, Europe, China, Japan for certain applications. And then it depends on your space. If you're a tools company, that's probably good enough. You can think about other places like in Canada, Mexico to cover the borders of the US. But if you're a therapeutics company, you want to be thinking about filing more aggressively. And there are ways to manage that cost to help you guys as you are raising money. You can budget that in so that you can pay for those expenses.
Allison, maybe I can add one other aspect to this. It also has to do with where do you think you're going to commercialize your product? If you think you're never going to go to a certain region, maybe you don't particularly care, so long as they're not manufacturing and distributing something to the regions that you're using. So the commercial footprint, your pricing position, how competitive you might be in that region are also considerations on where to cut the costs for filing.
So we've got another question from Sujata Iyer. How early in the ideation process should a patent attorney be involved? Do you recommend thinking about the kinds of claims that the inventor envisions and putting together the supporting information and having the attorney do a landscape or FTO really early in the process?
I can just jump in here first. We can start really at the very beginning. So when you have your initial idea, you can talk to us or whoever, your legal counsel, your IP counsel, to talk about those concepts and to come up with a strategy to protect that. This could then include things like doing a prior art search, which we do just to make sure that the concepts are novel. And when the time is right, we'll also think about doing a preempt to operate study to also assess the risk there when the time is right.
Question that hasn't been raised yet, but which I see coming in by Marcus QB3 is, what happens when your IP appears to have been stolen by somebody, or you see that somebody, especially at a large company, maybe even in a foreign country, is using your technology, what are the steps that you take when you're aware that they've got deep pockets?
Unfortunately, that's a really unfortunate scenario there, because companies with deep pockets can just bury you guys with lawyers and so on. So the name of the game is to prevent such theft. Is to file your own IP first, your own patent first, before you talk to a big company. Where this can happen sometimes is a smaller company could talk to a larger company as a partner, and someone there takes those ideas and thinks that it was theirs, and they file on it. So before that happens, if you can, and there are ways to manage these legal fees, is to file your own patents first before you guys talk to someone else.
Okay. So I guess it's just it's a bully phenomenon, and you just can only do what you can do, which is patent it before you have those discussions. It's interesting. Like last week, we were talking to people at a couple of weeks ago, people from a much larger pharma company, who said that the pharma company felt that they had liability when they're talking. They don't want to hear confidential information. They see that as a liability. I'm not quite sure what they meant, but he seemed seemed like he was being very upfront about it.
Yeah, Casper, that's a fantastic point. Big companies actually want to do things right, So they have people like me and Allison that says, look, we don't want our employees to be getting IP from someone else, and then that could contaminate our IP. So they tell their employees, do not talk about anything that is confidential to this other company, and so on. So they actually try to do things right, generally.
Allison, any further questions?
Yeah, I think I'm going to ask one, and this is from Dong Hee Chung. This question really addresses the transition that many of our listeners may be contemplating from the academic setting to engaging with a lawyer, or to working more in the startup setting. Are there red flags or things that you have encountered, that you've seen others encounter, that academics may not be thinking about in terms of this transition, either, engaging with lawyers or engaging more in the startup ecosystem?
I can take this one first, actually. So the biggest one that I've seen is, a PhD or a postdoc thinks that her invention is not special, and so why file on it? Why file a patent on it? And they go and they talk about them publicly, or they file papers and so on, when in fact they were special. So it's underestimating the value of IP. When the experts out of PhD programs think that, oh, well, this isn't really that special, it's obvious and so on, it could very well be special. So before you talk about your IP publicly, talk to a lawyer first.
And maybe another potential landmine that requires fighting one's initial tendencies. Academics are all about teaching people and who are coming in, by definition, learning things for the first time. When you're building your team, it's important to have, whether it's the IP firm or the other teammates, have somebody on the trip with you that could be a mentor, but someone that's been there and done that. That's part of the reason people are listening to this call, right? Because people have been there and done that. If everyone is going at it for the first time, it might be a lot of fun. It might be a fantastic training experience, but it's very rare that when everybody's doing something for the first time, no matter how charismatic and how good at selling they are, that they're going, and no matter how indignant someone might be, that they deserve the chance. If you really think your idea is worth $1 billion, that's not the time to give them the chance. And make sure that you have someone there that can help you along the way. It should not all be brand new, never been there, never done that. And it's easy to check, particularly for law firms. If a law firm has never had any experience in the CRISPR-Cas9 space, you shouldn't be giving them, for example, the IP. Like, oh, but we're going to do a better job because, we're going to cut our teeth on this. No, make sure that they've actually had CRISPR-Cas9 experience, right? If you're going to have investors that are coming to you, same thing. You want them to have invested in the same space.
Say you're you're looking to partner, you are partnering with another small company, a large company. How do you manage ownership and know-how when you have multiple parties in a collaboration? You're working together on something. Who's filing the patent? Who owns the patent? Can it be owned by two entities?
Yes, it's basically keeping track of who invented what. And for an inventor, the question really is who conceived of the invention? Is the light bulb versus this person helped to actually do it, helped to actually build this prototype. And such a person who just focused on building the prototype but not actually had the light bulb moment may not be may not rise to the level that this person may actually own part of this IP. So it's critical to keep track of who was involved, how did they contribute, and who do they work for to assess whether the IP is owned by your company or if it's co-owned between two companies. And from that perspective, notebooks and so on, could be helpful, to keep track of, who did this work, who did that work, such that when one is looking back with your lawyers to determine who are the inventors, you can do that more readily.
Great. I know we're at 2:00 and I want to respect people's times. There was just one final interesting small question from Gazelle Rastegar. Are we still doing this on paper? Like there are now digital notebooks. Is it still allowed this mishmash of, well, we've got paper notebooks, we got the digital notebooks. What's the standard these days?
Yeah, digital is fine. As long as it's confidential, it's a secure platform, it's encrypted, such that it can't be hacked. That should be fine.
Great. Allison, I think we should thank each other and our panelists and our audience for joining us.
Yeah, so thank you, Casper, for hosting, and thank you to our excellent panel, and thank you to all of you who joined us and stayed for an hour. We're sorry we couldn't get through all of the questions. There was a number of great questions that we didn't have a chance to get to, which is fodder for Casper and I perhaps having more of these sessions in the future.
Yeah, so like we said at the start, we'll be emailing people the link to the recording, and it'll be posted on both of our websites later. Thanks very much, and have a great Thursday.